There she is.
Here I am.
I see there are two folks, Ms. Berger, Ms. Howard, on the appellee side. Have you discussed how to divide your time?
Yes, Your Honor, I'm going to do 15 minutes and Ms. Berger is going to do 5.
Sounds like a plan. Okay. Okay, Mr. Gallagher, you're up.
May it please the court, Charles Gallagher for appellant Alberta Spiker. If I could reserve 5 minutes for rebuttal, I would like that. As our Supreme Court stated back in the Orsali case, trial courts should use their equity powers in resolving disputes relative to foreclosure sales. And our same Supreme Court in that same case talked about the elements or the standards for challenging a foreclosure sale. And from Orsali, we have learned in answering a certified question that the challenge is not limited to an inadequate bid price at the sale and can include some additional factors of sale, surprise, accident, or mistake imposed upon the claimant. Now, at the time of the sale in this case, and I won't belabor the facts too much, this is a dispute regarding a residential foreclosure and a dispute to the sale and challenge to the sale. Herein, there was among the parties, among the lender and the borrower, there was a reinstatement to occur. And the record contains the documents from the lender, which go over the reinstatement timeline. That timeline is very helpful, I think. On September,
Mr. Gallagher, the reinstatement payment, as we all know, and you're probably about to tell us, was unfortunately about 5 days late. So there was a reinstatement payment that I think was told had to be paid like on the 22nd of 2022 of September 9th, excuse me. And unfortunately, it wasn't until the 14th that the payment was made. So it was 5 days late, and everything had already been scheduled, right? I mean,
the sale had been scheduled.
It was all in place, right? Yeah. And I was, given those facts, I feel bad for your client. They missed it by 5 days. There was an effort to try to do this, but it looks like a lot went on before it got to this point. And I guess that my question really is, you take a position that the trial court erred in denying your motion because the parties were actively involved in loss mitigation, which I thought was a very sort of open-ended kind of thing. As long as we're talking, you can't really deny the motion. So that's the area that I'm most concerned about. If you can drill down on that for me, you take the position as long as the parties are engaged in loss mitigation dialogue, it's inappropriate for a court to deny a motion like the one you filed. And I have a hard time seeing that. So help me understand that a little bit.
Certainly, and it's not what I'm saying, it's what the Dodd-Frank Act says. That's a part of RESPA that was codified after the foreclosure crisis occurred. And under Dodd-Frank, when there is a request for assistance, be it a modification, a short sale, some other measure of assistance under a foreclosure, the Dodd-Frank Act, which is federal law, requires that the moving towards a foreclosure sale, foreclosure judgment stop during that process. And if I could just briefly address the facts of the reinstatement, I think that
the facts will be interesting. But so this is the position that I don't understand. And I understand about the Dodd-Frank Act. I understand what it says. I understand all that. But it seems to me the position you're taking is as long as the parties are talking, foreclosure is inappropriate.
I would think it's a little more narrow than that. I wouldn't say just talking.
I would hope it is. And that's what I want you to do is help me narrow that.
Sure. When you have a discussion on some finite set of plans, for example, a modification application, a short sale application, or in this case, a reinstatement discussion and quote and agreement. They're not going to render a reinstatement quote unless they're amenable to them reinstating. So when you have something substantive in that nature, certainly it elevates it outside of merely a dialogue among the parties. And here I think we have that. I think we have a substantive exchange among the parties. One of those types of exchanges that the Lupica case talks about. We favor settlements among foreclosures, not judgments where the parties are trying to resolve those. So we have that substantive back and forth here among the parties. The letter didn't occur out of the air. There was a discussion beforehand that they wanted to reinstate. Reinstatement letter was provided. And I think when you look with scrutiny at that letter, the reinstatement letter, it does not state what everyone else is alleging it states. There's no word deadline on there. There's a caveat at the back of that page that says that they can increase the amount for larger amounts. And to accommodate that, my client made a tender that was $2,000 in excess of the amount. The timeline, again, if I can just briefly speak to that, you have a reinstatement quote rendered on the 7th. We don't know how that arrived.
So was the final judgment was entered on August the 10th, 22, is that right?
I'll defer to the record on it. Yes, if that's what the record states, then that's what.
And can you point to any procedural or substantive irregularities that occurred up to and including the date the final judgment was entered?
Well, again, those not before the record right now. The record attacks only the issue of the pending settlement that should given pause to a hearing. There and if you look at the four corners of the actual emergency motion, there are things inside that rise to the level of surprise, accident, mistake under our SALI. You have issues regarding representations regarding staying of the foreclosure during this reinstatement period, during this reinstatement endeavor. So I mean, yes, I think we do in the motion itself to challenge the sale and the cancel the sale and object to the sale. There are facts in that motion which discuss the underlying judgment at issue too, though they are not a 1.540 motion. So just, back to the timeline, you have a reinstatement quote on September 7th. We don't know how that was delivered, whether it was FedEx, emailed, what. The reinstatement date, it doesn't say deadline, it says date, is September 9th, 2 days later. And this amount was paid on September 14th, which was 5 days from the date that it was the date that was stated. The foreclosure sale occurred 1 day after that. If you cull that letter, that reinstatement letter, there is nothing in there to say to impose upon the parties to contact the other side's counsel. If you look at the actual language, it says if your payments can be 10 days prior to the sale, you either wire it to us or contact us for arrangements. But there's nothing in it that says that a payment beyond the quote reinstatement date would not be accepted, would be rejected, or otherwise non-compliant. So the argument made on the other side is that this was a hard deadline. That word's not used in the actual letter itself. And so in terms of, again, we're policing this in terms of equity and looking at the terms of the payment, good faith there is shown. And I think that there's a basis under equity to go ahead and provide relief here. But again, the reinstatement amount was $36,1422, and the reinstatement payment made was $38,000 to accommodate that extra time frame that existed thereafter. And as a result of that agreed reinstatement, it was in excess of the actual amount, as well as what are incorporated in the actual motion itself, misrepresentations and statements regarding staying the foreclosure during this restatement. At that point, the Florida law triggers the entitlement to a hearing. The statute doesn't go ahead and have any flex or wiggle. It says, shall have a hearing. We're talking about, certainly the statute regarding the sales 45.031. And then the case law that goes beyond that does police these things in terms of, is there a surprise, accident, or mistake element alleged in that objection or that motion. And we submit that even in spite of this 2-day time frame that was given, the 2-day time frame to reinstate, again, we're policing it on equity. We're not policing it on a more stringent standard. But as a result, we believe that there was facial sufficient grounds set forth in the motion. Now, there was a hearing request in the body of that pleading. Another thing that's very, very kind of telling too here is the time frame between the motion, the emergency motion, and the order. It's less than 24 hours. The filing was on 9/15 at 1:30 in the afternoon, and that there was an order the next morning at 11:47 a.m. So we have a less than 24-hour time frame among the two, which certainly is a quick response, obviously. In our emergency motion, we attached both the exhibits for the wire that it was sent, as well as a reinstatement quote. Shortly thereafter, there was a tender of the funds to redeem the mortgage, the final judgment funds, $122,000, $122,182.32. Our position is that the emergency motion alleges facts in support of that element of surprise, accident, or mistake. For example, the reinstatement among the parties, the representation.
Mr. Gallagher, I'm gonna have to like pause for a moment. We're having some
Yeah,
technical difficulties here.
I'm not getting this.
And I'm gonna stop your clock and start you back when we go again. Hold on one. I'm sorry. These things happen.
No worries.
Judge Northcutt, could you talk for me, please?
I can talk to you all day long, Rita,
Okay. Thank you.
as you well know.
We're good. Thank you. Technical difficulty solved.
Excellent. Thank you, Judge Black. Okay, Mr. Gallagher, you're continuing.
Thank you. And so as to the emergency motion, there were numerous grounds set forth in there, specifically the reinstatement payment, specifically the reinstatement discussions among the parties. Also, the representations by appellee that the lawsuit would be stayed during this reinstatement process. Also, representations by appellee they would cancel the foreclosure sale, and the failure of plaintiff to confirm receipt of the wire transfer, and then finally the Dodd-Frank dual tracking violations we talked about earlier. So an issue would be, whether or not that was an appropriate denial of that motion, and a denial without there being a hearing provided. While the trial court gave no factual basis or legal basis for the order, it did drop a footnote in that order, citing the case of IndyMac versus Hagan, a third DCA case from 2012. What's significant is Hagan is a precursor to Arsali. Arsali talks about Hagan, and the difference among the two is that Hagan will state that you must have some issue regarding the inadequacy of the sales price to challenge a sale. Arsali said, no, that's not the case. You're permitted to go ahead and address one of those other grounds we talked about, the surprise accident or mistake, and Arsali. And this very court, adopted Arsali and Gavadian in 2020. That's and ironic, but that Hagan actually has a hearing as part of that. The trial court in Hagan provided a hearing to their parties, but the trial court here dropped a footnote about Hagan, and as a result, we are left with the idea that the trial court relied upon that. And for that reason, that's why we have the issue of maybe these dual standards here. Certainly, I think that Hagan is the incorrect standard for the trial court to consider under these facts. Arsali had already been decided. Hagan was old law. Arsali was new law. Arsali was a Supreme Court case where the Supreme Court answered a certified question, stating that no, you need not address there are factors beyond the inadequacy of sales price. So unlike our case, Hagan did hold an evidentiary hearing. Here we have a denial of the appellant's emergency motion, and we believe it's in error for four reasons. First, that there was the motion itself was facially sufficient. Within the four corners of that document, we set forth various factors, various reasons that meet that same surprise accident mistake standard, and that other courts have accepted. Other courts have accepted that a reinstatement is a basis for for relief to cancel the sale or to avoid the sale. Secondary, the emergency motion should have. Second, in the event the court did not deem that motion to be timely, we state that the court should have looked at that as a motion to vacate under 1.540, and looking at the factors of 1.540, we also submit those same facts alleged in the motion would meet muster. Now, certainly we did later file a motion to vacate with an affidavit. But if there was some ability to go ahead and look at that motion, and it was not timely because the sale had occurred, we submit that the court had that lens of a 1.540 motion to vacate. And I won't belabor the point on substance over title or over form. Finally, again, the third issue that we state is that the parties were involved in, and I use the word broadly, loss mitigation, but here in this case, it's more pointedly a reinstatement of the loan. There had been the communications that led to a letter that talked about how you do that, the amount you do that for, and again, the time to do that. Again, looking at that letter with scrutiny, there's no deadline word on there, and there's no term on there that if it's late by days, we're going to reject it. But that's all that was provided by the lender in this case. Finally, we have no, and I think we're fairly brief the issue on the entitlement to a hearing under these facts. The case law supports that universally. When you have a facially sufficient basis for an objection or motion to cancel, you have an entitlement to a hearing under the case law. Yes, certainly, if you don't allege sufficient facts or muster to meet that right, you wouldn't be entitled to a hearing. But the facts in this case support that those good faith facts alleged in the motion would rise to the level of a hearing. And finally, the court provided no reasoning as for its ruling other than citing to the Hagan case. And if we're extrapolating the Hagan case would be an incorrect standard for the court to utilize relative to the cancellation of the foreclosure or the moving to object to the foreclosure sale. Looking at the case law on the basis for this, Florida courts have held that a hearing is required on an objection. We've cited a number of cases to that effect, Nelson and Ulay and many others. But the idea that once you set forth your basis, your reasoning, and here that again stems from some representations regarding staying in action, some reinstatement communications, and a tendered reinstatement in advance of the sale date. These are the factors that are alleged in that motion. And at that point, we submit that a hearing will be the next step that's appropriate under the case law. It's not a close call. Once there is the factors that are laid out that would support that a surprise accident or mistake, that our salary would compel that outcome. So we submit that the wrong standard was used in Hagan, but beyond that, not providing us with an underlying basis for the ruling would further be a basis for an appeal as well.
Okay, you are getting into your rebuttal time now, Mr. Gallagher.
I will go ahead and terminate and reserve then.
Sure thing. Okay, so Ms. Howard, you're up.
Yes, Your Honor. First, I want to answer your question. In this case, Dodd-Frank does not require the stop of the foreclosure. And if you look at the cases that they cite in their brief, on page 15 of their brief, the Wells Fargo case, it was the bank who filed the motion to cancel. In Gavidia, it was both parties. There was a settlement already entered. There was a reinstatement that had been completed. In this case, what we had is the bank made an offer. And it is the language in Exhibit A is very clear. If you look at the record on page 316 of the record, the last sentence of the first paragraph of the letter states, reinstate your loan by making a payment in the full amount by the reinstatement date noted below. So it is clear, if you want to reinstate your loan, you have to make the payment, but the date noted below. And they make a lot of noise about the allegations in the emergency motion. But if you look at the emergency motion, that first of all, I don't know if it was ever treated as an emergency motion and when the court got it exactly. But the language is very general. They say the bank promised that there's not on such and such a date, the bank said this, and this is the date that we had, and this is why this is wrong. And the exhibits to the motion contradict the language of the motion, because the exhibits to the motion show that there was a deadline for reinstatement and that the reinstatement payment was not made on the date that it had to do. So it was very clear for the trial court, just looking at that motion, that there were no unfulfilled promises. There was a date. There was a, we said, yes, you can reinstate. This is when you can reinstate, and this is what you have to do to reinstate.
Howard, help me a little bit, because I'm still struggling with the Dodd-Frank Act and where exactly the line is drawn on loss mitigation discussions. So let's recast this scenario.
Mhm.
Add some facts to the facts that we know exist to demonstrate to me when the Dodd-Frank Act would stop a foreclosure action.
Well, I think it's clear in our Sally, because in that case, the bank made an offer. The mortgagee, gosh, I'm getting them wrong, but the debtor accepted the offer and paid in time. And because there was a payment in time, at the right time, then it is stopped, because a settlement has been reached. Your Honor.
Well, I know, except for, you know, in this situation, there was basically an agreement of some type reached, a reinstatement quote was provided, a number was given, and a deadline was given. So obviously, if the payment had been paid before the deadline, we wouldn't be here. There's nothing to talk about, right?
Right.
Okay, so that's the problem I'm having with the Dodd-Frank Act. There obviously were ongoing fruitful discussions, and
I
right.
don't think that they were fruitful, Your Honor, because the bank made an offer. The fact is that let's go to basic contract law. In all these cases that are cited in page 15 and beyond of their brief regarding that mitigation was ongoing, mitigation had actually been completed. The parties had agreed to an amount, and the amount was paid on time. Here, the bank made an offer. The bank gave them the amount. The bank said, this is the amount you have to pay. And
Is time of the essence of this date?
Your Honor,
And
because
why? Why would it be?
time is of the essence, because every day.
Well, no, I understand practically what you're saying, but is there any agreement anywhere, like the reinstatement statement itself says time is of the essence? You know, in the legal sense, not in the practical sense.
Well,
You know, you have time of the essence clauses in contracts that tell you the dates are hard and fixed. Do we have one here?
I understand what you're saying, Your Honor, but here it says if you want to reinstate, you got to pay by this date. I mean, that it can't be any clearer. It tells you you have the option to reinstate, and your
Well,
option can be.
You only missed it by 5 days. And so if time is not of the essence, that's a de minimis period of time.
Well, Your Honor, by 5 days, but it was the day before the sale. The bank was not notified.
The operative word there is before.
The bank did not know that the bank had no knowledge that the payment had been made on the date of the sale. You're looking now at a third party, a good faith purchaser for value that whose rights are going to be trumped. If you're talking about due process, they have due process rights too. And in this case, Your Honor, there's one more thing that you're not considering, and it's that there's still a pending motion to vacate, and the certificate of title has not been issued. So the trial court can still consider a lot of the things that they're saying, but the emergency motion was not a verified motion. It does not include any affidavits. It includes 2 pieces of paper, one that says the payment has to be made on this day, and the other one that says the payment was not made in this day. So I don't think that Ms. Biker's due process has been trumped. they still have a chance to challenge the certificate of title. They still can go and prove to the court why it took them so long, why they didn't do it before. I mean, there's still things that they can do before the trial court. The case is not completely over, but I think it would be unfair to make this, to say that the foreclosure sale has to be undone when you haven't had, the purchaser hadn't given the purchaser the chance to talk about their rights. Because it's not just the bank. If the bank had purchased the property, if we had gotten title to the property, I think maybe the time is of the essence argument would be better. Like, time is not of the essence, you have the property. But here we have somebody else who has purchased the property and paid good money for it, and there's nothing wrong with the consideration that they paid, and they have a right to be heard on their rights. Any other questions from the panel?
Okay.
I think I'm going to leave the rest of the time then to Ms. Berger.
Okay,
So they
thank you.
can,
Thank you, Ms. Howard.
thank you, Your Honor.
Ms. Berger?
Good morning, may it please the court. My name is Erin Berger. I represent Beta Gulf Holdings LLC. It is the purchaser and intervener in this case. Your honors have already heard from appellant's counsel and the bank's counsel about some issues that my client isn't particularly able to speak on, particularly the issues between them in terms of loss mitigation, reinstatement. But there are some issues raised in the briefs that I think warrant additional discussion, particularly that the appellant has not cited any authority that suggests that they are entitled to a hearing in this case. First, I take exception to the characterization of the IndyMac opinion as applying an incorrect standard. The issue there wasn't that there was an inadequate bid price, or that that was the only other issue that the court just discussed. So there, the bank was a successful purchaser and the clerk issued the certificate of sale, and then the mortgagors filed an objection to the sale and raised issues with regard to the final judgment and there being fraud in the obtaining the final judgment. The court was going to allow an evidentiary hearing on that, and the bank moved to have the certificate of title issued. The district court ultimately found that the trial court did not err or did err in waiting the issuance of the certificate of title pending that evidentiary hearing, because there weren't sufficient grounds stated in the objection to sale to warrant a hearing. The court found that the trial court could have summarily denied that objection without a hearing because there weren't sufficient grounds stated. And in the decision, it specifically says that the Hagen's motion did not challenge any conduct that occurred at or which related to the foreclosure sale itself. I would refer also to the Volinsky case that was cited by appellant in their brief, in which there, again, although there are cases cited in that case and that were cited by appellant in her brief that suggests that an evidentiary hearing is warranted, those situations involved issues where the objection to sale was pending when the court ordered the certificate of title to be issued. So that's a different factual scenario that we don't have here. As Ms. Howard pointed out, we don't have a certificate of title yet, but we do have a properly denied objection to sale. Also in that Volinsky case, the court found that the Regner case, the Valls case, and the Bajeliak case from the 5th District did not apply, because in those cases, those cases involved proper bases to challenge a sale. And the court in the Volinsky case stated that those cases are inapplicable because the Volinskys failed to plead or offer any supportive fact or anticipated evidence which would support the conclusion that he was entitled to relief. So the IndyMac case and the Volinsky case support the trial court's actions here in summarily denying the objection to sale. The objection to sale raised two issues. One, that there was settlement and active loss mitigation. And as Ms. Howard pointed out, that argument was contradicted by the exhibit to the objection itself. There was nothing to consider. The only other issue that was raised in that motion was that there were errors related to the entry of final judgment that would be raised in a quote unquote formal motion to vacate, which Ms. Howard also pointed out is still pending. As in IndyMac, the court doesn't have to allow an evidentiary hearing on issues that should be raised in a motion to vacate a final judgment as an objection to sale, because under the statute, it's not a proper challenge to any conduct related to the sale. Although the statute does say, 45031 does say that objections shall be heard, this court in the Schlischi, I cannot say that case name, Schlischi case, stated that that doesn't require an in-court proceeding with counsel physically present. Here we have a situation where the complaining party's argument was heard. They presented it as an emergency motion. It was heard on an emergency basis. And the court denied it because it contradicted itself and didn't present any other sufficient basis for this court to warrant any further consideration. Here, also in the Schlischi case, the complaining party was the third-party purchaser who was not given an opportunity to present any objection or, concession to the motion to vacate the sale, and their due process rights were violated. Here we don't have that issue. There's been no contention by the appellant that there was any pre-sale misconduct. Judge Black's question begged the issue. They didn't move for rehearing of the final judgment. They didn't move to appeal the final judgment. There was nothing in the motion to cancel the sale or the objection to sale that suggests that they did not receive notice of the sale, that they were unaware of it. And in fact, their pre-sale actions suggest that they did have notice of the sale, were aware of it, and didn't do anything to try to stop it other than issue a late reinstatement, excuse me. There were no equitable factors that were identified in the motion to cancel sale that would warrant vacating the sale. We do feel badly for appellant, but the appellant's arguments are simply an attempt to invoke the trial court's benevolence or compassion, but that under the First Bank of Puerto Rico versus Othen case and the Republic Federal Bank versus Doyle case, those are not grounds to support the cancellation or objection to a judicial sale. The Gavidia case is factually distinguishable in that both the bank and the mortgagors in that case filed pre-sale motions to cancel the sale, recognizing that the mortgagors had paid the reinstatement. Here we have a unilateral statement that there was some agreement, which after the sale and after these motions were filed, the bank denied. And in the Gavidia case, a distinguishing factor as relates to my client is that any third party would have been on notice that there was going to be a challenge and would have prevented perhaps a third party from bidding on the property. The Arsali case is also distinguishable in that there, as Ms. Howard said, there was a concession by the bank that there was a pre-sale agreement and that payment was made in time pursuant to the communications between Chase and the client. Here, we do not have that as evidenced by the exhibit that was attached to the motion to cancel sale. And again, the reasons why this case is distinguishable from the authorities cited in the appellate's initial brief, I've referenced already the Regner, Belgic, and Val's distinguishable features in that in those cases, there were facially sufficient bases to warrant relief. In the Val's case, it was ineffective service of process. In the Belgic case, it was that the bank mistakenly failed to send a representative to the sale. The other cases cited, the Wells Fargo versus Lupica case and Gavidia case, that's where the foreclosing bank sought to vacate the sale and joined with the borrower to seek that relief. We don't have those facts here. We don't have a proper motion to vacate or any of the issues that are presented in the still pending motion to vacate before the court at this point. So based on the issues that were raised in the appellant's initial brief, we do not have a basis to overturn the discretionary ruling of the trial court. And Beta Gulf Holdings requests that the court affirm the denial of the motion to cancel the sale.
Okay, thank you, Ms. Berger. Excuse me, Mr. Gallagher, you're up for rebuttal.
Thank you. And counsel brought up the Valinsky case, and Valinsky case is unique because you have two sets of pro se objections filed. And certainly neither one of those two meets muster. One of those talked about not getting notice, which otherwise might seem to, but the way it was framed apparently was not sufficient. The other notice talked about the value of the property. And so the notices that were seen in Valinsky are a far cry from what the trial court saw in this case. And one of those allegations in the motion also talks about the age and the incapacity of Ms. Spiker, which is certainly not a passing fancy. I think that Judge Morse is correct in his assessment of this being a de minimis time frame involved. Again, we're talking about a 2-day window provided, and that's assuming that we had immediate receipt of that letter, our client immediately received that letter, and then the fact that the tender was made in an amount to compensate for the extra 5 days, and far exceed the extra 5 days. That amount of over $2,000 from the reinstatement amount is to show the good faith and to show that they're standing to pay that amount over and above. The idea behind the general language arguments of appellee are best resolved by an evidentiary hearing at the trial court. If there are issues that are set forth in the motion, and I'll take issue with the fact that the motion's got to be verified or an affidavit. There's no case law that says that a motion to set aside, a motion to cancel a sale, nor an objection must be verified, nor whether it must have an affidavit with it. Certainly the case law on 1.54 motions is different, must have some affidavit or sworn testimony. But on this motion before the court that was denied, there is not any requirement to that effect at all. And so, again, this case is a place where courts should use their equity powers to resolve disputes on these foreclosure sales, just like our Sally said, and this court has adopted our Sally and Govidian itself. And so, here there's a concern because we have asserted, despite factual arguments to the contrary, bases for surprise, accident, or mistake under that standard. Finally, I think that the lack of a hearing, we'll stand on our brief, but the case law overwhelmingly supports that when you submit facially sufficient allegations, which are set forth in our motion, there's an entitlement to a hearing. It's not a matter of some discretion, but like the cases where we're dealing with Hagen, there was a hearing in Hagen, there was a hearing in Govidian, all these cases. And at the end of the day, the trial court simply did apply the wrong standard of Hagen. Our Sally is the law at that point in time. It's a year past Hagen, and the case law beyond that also supports the our Sally argument, the our Sally rule of law. So we would ask the court to go ahead and reverse the trial court's order and remand the case to the circuit court for an evidentiary hearing on these matters.
Thank you, Mr. Gallagher. Thank you all three. In order to leave our virtual courtroom, you should click the button that says leave on the Zoom screen and you'll disappear into the ether.
Thank you, Your Honors.
Thank you, Your Honor.
And